So Julie, how eager or how willing, how cooperative are the clients? It's great for you. You're their outside counsel. You've been retained. But suppose Julie works for you, and how receptive are your clients to working with a lit support manager, with someone who's not an attorney? Is that not an issue?
I haven't seen it as an issue yet, but I'm typically working with our attorneys. So I partner up with the attorney and sometimes sit and just be quiet because they know completely what they're doing and I don't need to say anything. And then other times, saying, well, have we thought about doing this or trying that? So I think we always work as a team. It's very rare. Now, I may work with in-house IT directly, back and forth on things, right. But as far as anything strategic, the attorneys are pretty much always involved in that. And so your presence isn't really going to be considered an issue. It's not going to be considered wallet whipping internally. Right. The clients are okay with that. How about the IT? How do they receive you? I've always found, of course, as an outside consultant, IT sometimes view me as a threat to their credibility, not to their position as much as their credibility. You ever get that sense? I think you have to approach it gingerly, and you want to make sure they understand you're not there to question them about whether they've done the right thing or the wrong thing. You're just trying to figure out what they have so we can figure out a strategy. In most cases, I found them to be overly cooperative. Oh, well, let me show you this. Let me give you this. Here's,
Because you're not used to anybody talking to them, right?
Politely.
Yeah, good point.
Occasionally, I think you get somebody who's a little uptight, and you just have to try to assure them that, really, you're doing a great job. Everything you're doing is fabulous. What we just need to figure out is how we're going to deal with the lawsuit.
Right.
One of the challenges when dealing with IT is that the job function is completely different.
Yeah.
Although to lawyers, it looks like it's all that computer stuff, mumbo jumbo, blah, blah, blah. What an IT department does is make sure that the network is up, make sure that people have access to the documents that they need to have access to. It's a little bit different when you look at it through a litigation prism, that what we're asking them to do is completely different. And so the skill set that you need to be successful when dealing with electronic issues may sound very similar when you're dealing with litigation versus the real world. But it's kind of, like I say about other things, real world litigation facts, real world facts and litigation facts are often backwards. If you have a car accident and somebody dies, that's a bad real-world fact, but in terms of your damages, it's a pretty good litigation fact. Same thing's true in e-discovery, that there are things that are very good to do and very easy to do in the real world that don't always line up.
Right. One thing I know Browning would have asked if he were here is somewhat related to that, which is not just litigation, but litigation hold. How often do you get called in too late?
Yeah.
Okay, so that I guess answers the question. We're not consulted enough on the outside, of that litigation hold process.
I mean, you've dealt with a lot of litigation hold issues. To me, it should be the second piece of paper that goes out. And the other thing that I find people don't do, maybe your experience is the same or different. People don't follow up on the litigation hold. It's like they issue it like they're issuing the 10 Commandments, and as if that's all they needed to say.
A process to
right.
Yeah.
I have a case that I was telling Julie about between our break where it involved the disqualification of counsel. And so the case is now, we're 14 months in, no documents have been produced because there was this whole issue of who's going to represent the other side. We've issued 3 litigation holds. Not different holds, but we've reissued the hold 3 times because we want to make sure that everybody knows what's going on and we've captured what we need to capture. And my sense is that's not happening on a widespread basis. I don't know, Julie.
Yeah, I think I'm sure there's times where I'm not brought in time, but more and more, I think everybody's getting this.
That's good to hear.
I mean, we've spent a huge amount of time on education programs for the attorneys. I also, every case that comes in the door, I send an email out to the attorney on the case saying, hey, I saw you got this case in, I'm here to help you, let me know how I can help with hold and preservation and identification. So I think doing that, I think with some clients, I've talked to them about bringing like a product in to help with their hold process, some of the automated, because a lot of the automated tools now charge like per custodian or per case, so you don't have to buy the software. It's more economical for people.
What's the reaction to that?
some of them are like, really? There's something like that? This is great. Other ones are like, oh, I've got an Excel spreadsheet, I'll just do it over here. And that's fine. In some cases, that's all you need. As long as you're sending out reminders and you're tracking your acknowledgments and stuff, you can do it in an Excel spreadsheet.
That actually leads to a related question in the sense of software. What do you do if you find a client who has a software that you just don't think is up to the task? We're seeing that in the BP litigation. There's some real tension between corporate counsel and outside counsel on the right choices of software.
That's a hard question that is more pervasive than you may realize. Yeah. I have often said that sometimes it strikes me that corporations make their decision about which company to go with based on who most recently brought them kolaches. And you see that. And one of the things that you don't always expect as an outside lawyer is that a lot of the vendor selection has been done before you ever get there. I've got, in the state of Texas, and I like to think maybe elsewhere, people know that I've done a lot with e-discovery. They know who I am.
Right.
So vendors come to me often saying, help us get in with this corporation. I'm the wrong person to talk to. You need to be talking to the lit support people inside of these companies, because I would say in 8 or 9 cases out of 10, that vendor selection has been done before I got there. Mm-hmm. And it's not through the same vetting process that Julie or I would do, asking the right questions. And I'm not even sure I would always ask the right questions, but I know some of the right questions to ask. And so that's a real ginger issue, because an issue that has to be handled gingerly, because the problem with that is you're not going to be able to disrupt that relationship. You're not going, and you're going to fight some things that you really can't fight. So you just have to find a way to work within it. And I think it's not only a quiet conversation with the company, but it's also a quiet conversation with the vendor. You're here. It's like having a kid sister. You can't get rid of them. You're just going to have to learn how to deal with them.
Try to get them on your side.
Right, exactly. Do the best you can.
Okay. I think the more, as a law firm or an attorney, you can do the project management piece of that, and you manage the vendor, the better off you are. If just because the client hired a vendor doesn't mean the data goes there and it goes up and you go, okay, I'll review it. And I mean, no, the data goes from the client to the vendor. You're on the phone with the vendor. How do you process? How do you dedupe? How does your tool index documents so that we can understand search technology? When's it going to be up? When are we going to be ready to do review? In some cases, it's not even the technology. The clients are also hiring the review team. Right. And so they're using external companies. And as long as you have your QC processes in place and you're managing the review and you can defend the review, I think that all of that's important when working with clients who have kind of already picked that piece, and in some cases it works quite well, I think.
And even if they have the best vendor in the world, you still need to do a lot of that stuff.
Well, and let me circle back. We're just winding down on our time here, but we never really got to the heart of what your panel was that you spoke on, which is project management. Any thoughts on project management that you would like to leave people? Things you maybe didn't get to follow up closely on the panel on, and you'd like to just say some final words about?
I would say that you should always plan for some failure to occur. Either, we mentioned this during our panel, but our hard drive may not spin up. The custodian, who is the vital custodian, may have been transferred to Australia, for all you know. I mean, there's always something that will come up. So be contingency planners. If you don't do that, it won't stop the emergencies from arising, but at least you'll be a little bit better in terms of your positioning. And frankly, if you've taken the time to build a relationship with the other side or with the judge, you'll have some credibility and be able to get out of some of those things.
And I would agree with the planning. Planning period. So many times when we get stuff in litigation, we're in execution. We're executing a plan that doesn't exist. And so as a result, it's very reactionary. Everybody's always running around, going nuts and trying to get stuff done in unreasonable time frames. If you actually plan out what's going to happen and, what resources you're going to need and the tasks that are going to take place, you have a much better shot at managing the case instead of the case managing you, which is what I see so frequently.
And you know, you mentioned something that clients' reaction to that. What I often say to them is, we can either make a conscious decision or have a default choice. And if we put a plan in place, we're making a conscious decision about how we're doing things. If we don't, there will be a default choice made for us, and we'll be running around like chickens with their heads cut off.
Right.
And that is so true. Okay. And the other thing that Julie brought up during our panel that just remind you of, yeah, because it's such a great point, is to do an autopsy at the end.
Yes.
Excellent.
To come back and see what worked and what didn't.
Right. So it's an ongoing process for you as well.
Right. And provide great client service, and clients love that kind of stuff, and it helps you. It's a great client development tool.
Great. Well, thank you very, very much for your time. Thanks for taking time out of your schedule. Once again, our guests, David Chaumette and Julie Brown. We'll let you get back to the exciting stuff on the exhibit hall floor. Are you speaking any more today?
Yes, I'm talking about getting ready for the Rule 26 conference at the end of the day with John Barquette.
Great. Julie, you done?
I'm done. I did yesterday and today.
Excellent.
So.
Excellent. Well, thanks again for your time. Enjoy the rest of the show, and we'll see you next time in the e-discovery zone. Boom.